Good afternoon. My name is Deborah Goodsell, and I'm the director for the Clinton Senior Center, and I'd like to welcome you all here tonight. This is one of a Caregiver Series that we're going to be having on a monthly basis. Tonight, we're going to be talking legally speaking with Attorney Bill O'Neill here from Clinton, and Bill's going to let us know some of the things we need to look out for, some of the things we should know when we're talking about legally speaking as a caregiver, as far as being a caregiver. So Bill, thank you so much for coming, and I'll leave it to you.
Thanks, Debbie. I'll try to keep my voice up, and but if somebody can't hear me, please, give me a wave. So I don't mean to be talking one direction and avoiding the other. So I thought we'd talk about a number of things today. One is mass health. So just kind of everybody seems to be concerned about what are the rules for Medicaid and mass health benefits if somebody goes to a nursing home. We'll talk about the importance of having a power of attorney, a healthcare proxy, some documents related to things that you need, you should have while you're alive, and of course the will, who gets what when I die. So, so I'll kind of take start off with the things that you should have or that are important while you're alive. The first one is a power of attorney. And that's a document that you give authority to somebody to act on your behalf. It's a document that allows them to sign your name and bind you for legal matters, financial matters, things that you need to do to conduct your affairs, like paying, could be as simple as paying checks. If you give somebody the power of attorney, they don't have to be on your check register itself or on the checks, because if you brought the power of attorney to a bank, the bank would then take a copy of it. They would now have you on as an attorney in fact for the account. So it's like you're not giving up disclosing anything to somebody with your checks themselves. But the power of attorney, they said, would allow that person to sign your name and bind you and act on your behalf. It could be filing a lawsuit, it could be filing your income tax, it could be paying your bills. Just the things that everyday life, things that you have to tend to yourself. And I can talk about that a little bit more. But in the power of attorney, usually we include a paragraph that says, if I need a guardian or if I need a conservator, here's who I'm going to appoint, or I suggest to nominate to the probate court for it to appoint. The next thing is a healthcare proxy. And if most of you have gone to the hospital for any kind of a surgery or any type of procedure, they will make you sign a healthcare proxy. So that's like a power of attorney, but it's only for making healthcare decisions. It's a powerful document in that a lot of people will kind of laugh. They'll say, well, here's your chance to pull the plug on me. And so it is that important. Hopefully if you go in for some type of planned surgery, the doctor's going to ask you, well, if we find this, what do you want to have done? And it's your decision. But if they find you in the snowbank in one day and you can't communicate what you want done, then they're going to revert to the healthcare proxy. Kind of as a guide, and as I said, a lot of people will kind of joke in the office when they're signing it, well, here's your chance to pull the plug on me. The reality is I think people are really struggling with making what is the right decision. So we have something that we use called an advanced care directive. And the advanced care directive indicates it's a guide to the healthcare agent. And it says, if I have an incurable disease or illness and it's terminal and it's certified to be that by somebody who has actually examined me, then I'm saying, and it's witnessed, keep me comfortable, keep me as pain-free as possible, but I don't want extraordinary means if I'm going to be left in, so if I'm only artificially extending the time of death. And I think that weighs heavily on many people's mind is, there's got to be something you can do. So it's something that eases the guilt of whatever that decision is. And we have a form, a HIPAA release form, health information privacy, that you authorize the release of certain information to the person, and usually you would name the same person that you have as the healthcare proxy. Now, a couple of times that's come up, when, like I had somebody who spouse was in the nursing home and they died, and the person wanted to get the medical records and they couldn't get them because there wasn't a HIPAA form released. So the way around that, we had to open the person's estate to get somebody appointed as the personal representative, and so then they could get the medical records. So upon death, the power of attorney ceases. No more authority. Once, I think if you've signed something in good faith, a check, and it was out there somewhere and you didn't know the person died yet, that's fine, but you can't, continue writing checks after you know the person is deceased. The healthcare proxy does not include burial instructions. So the healthcare proxy, again, once you've deceased, there's no other decision to make regarding that. So those terminate upon death. And then the will is the document that says who gets what. Now I will tell you, a will can be very specific, it can be very general. It can be, and I'll say, and most the crowd are women. Women tend to be much more thoughtful about that than men, and they may say, well, I have these specific bequests. I have this ring, it may be of great value, it might not, but it's a remembrance or it's a connection to my granddaughter, and I want it to go that way. But so you can name specific bequests. Money bequest to your church or any charitable organization. You can name specific bequests to individuals. Or it can be very general. It can say, and many times with spouses, it says everything goes to the other spouse, and if I'm the last one alive, then it goes equally to the kids. I guess in over 33 years of practice, I realized that I would say in doing the will, it's whatever you think is equitable, okay? Equal doesn't mean equitable. And people rationalize things many different ways, and you can say, well, geez, the oldest child, it only cost us X amount of dollars for college, and the youngest one, it cost us, twice as much because of escalating prices. Or you paid for a wedding for a daughter. You can rationalize things many different ways, but in the end, it's whatever you think is fair and reasonable, that's what counts. Now, I guess if it's something other than equal, then I wouldn't necessarily start talking about it with the rest of your family, because that can only cause more friction while you're alive. That's something to consider. I'll tell you, I use the term personal representative, so I'm going to explain that. And for a couple of hundred years, if I died with a will, and you were the person in charge, and you were male, you were the executor, and if you were female, you were the executrix. And if I died without a will, and you were the person in charge, you were either the administrator or administratrix. So about 5 years ago, Massachusetts adopted the Uniform Probate Code, and now the person in charge is referred to as the personal representative. So, like if you get a draft of a will, you can, it kind of jumps out at you, but if somebody's looking for the term executor, you just don't see it there. Basically the same responsibilities and all that, but a lot of the Uniform Probate Code changed things to somewhat talk about situations that perhaps weren't around in the in the early 1900s. So if you had divorces and children from multiple marriages and things like that. So it kind of tried to lay the groundwork so that people were treated somewhat fairly. So now there are problems that can come up if you don't have things. So like I said, the Uniform Probate Code will dictate who gets what when you die, if you die without a will. So if you die without a will, that's it's referred to as dying intestate. Testate being with a will, intestate being without a will. So if you die intestate, it's the court is going to determine who gets what. Okay, and lots of times you would have one spouse die, doesn't have a will, and the house wasn't owned jointly. So one spouse would get a certain amount of money and the kids would get a certain amount of money. So there's things like that that the rules of intestate succession apply to. But if you had problems while you were alive, and again, they find you in a snowbank in one day, and there's no power of attorney, there's no healthcare proxy, there's nothing that is going to guide you, and you'd like to say, well, geez, I've been married for 40 years, and well, that's nice, but do you have a piece of paper that tells you that you have the authority to do something? And if you don't, many times they'll say, well, you have to go to the probate court. So the probate court is in Worcester, and this is where you would go if somebody needs decisions over their person. Okay, that would be referred to as a guardianship. If there are decisions to be made over their assets, that's a conservatorship. So those are things that, one, you would need a medical certificate from a physician who's examined the proposed ward. And then you need to file a petition with the probate court, give notice to all of the so-called heirs at law. So if I'm married and I've got 4 kids, all 5 would be considered an heir at law, and they would have to get notice. And occasionally you have somebody objecting, well, I think I should be the one, and the other one thinks, well, I should be the correct one, and the typical family things. But the probate court, once they decided who was going to be the guardian or conservator, they appoint that person. That person then has a document to go to the bank or go anywhere and transact the person's affairs, and they have to report to the court annually what they've done. So it's like, in the beginning they sign an inventory, here's what we found in the person's name, and then over the year you are supposed to do an accounting, what's come in, what's gone out, here's what's left over, and that accounting gets approved by the probate court. If you have somebody who, very likely they would appoint what's called a guardian ad litem, and that's an independent attorney. Once the person files the accounting, then they're going to say, great, now we're going to have this independent person look it over. And that person, they can get very involved, and or they can be very general in their analysis. I had one where somebody came in, they said, well, do you think that's the right investment person that you're having? And so on one hand you say, well, geez, that's kind of overreaching, but they have the right to ask questions. What kind of, are you in risky investments, or are you in conservative investments? Similar to if you went to a financial planner, they're going to say, if you're 28, they're going to say, well, you have plenty of time to ride out all the ups and downs. And if you're 78, they're going to say, well, geez, you don't have a lot of time to ride out an economic downturn. So the conservatorship and the guardianship do require annual accountings, and they're under the control of the probate court. Now, in the will, when somebody dies, the assets that are administered are considered probate assets. And all of us have probate assets and non-probate assets, I would suspect. So a non-probate asset are things like life insurance, IRA, 401k, 403b, any of those deferred accounts, an annuity, because they all have a designated beneficiary. So if you have a designated beneficiary, when you die, the person who produces the death certificate to the company will get the payment of the money if they are the named beneficiary. So those are considered non-probate assets. A probate asset would be an asset, a bank account just in my name. If I had an IRA and I had a parent as the beneficiary, but by the time I die, the parent had died, then there's no beneficiary, and then it goes into the probate court to be administered as part of your will. A lot of people raise the question, well, when does it go to the Commonwealth of Mass? And I would tell you, virtually never. In 33 years, I've never had anybody have an asset that they refer to that as escheat, E-S-C-H-E-A-T. I've never had anybody lose their property to the Commonwealth of Mass. Now that's not to be confused with unclaimed property, because This would be, if you die with absolutely no relative, then that's when it goes to the, would go to the Commonwealth of Mass. The unclaimed property is a whole bunch of rules that the financial institutions have been assigned to them. They say if you have an account that's inactive, I might be off, might be 5 years or 6 years, or if you have an old check that hasn't been cashed, then eventually they are responsible to get that to the treasurer for the given state, and then you can go online. It's always in the newspaper, but I'm not sure that in the newspaper and the website, if you go to the Mass State Treasurer's Unclaimed Property Division, you can type your name in. And if you have a married name, you can type in your maiden name. And you can either, if you typed in Smith and left it, across the Commonwealth of Mass, you're probably going to get, a few thousand hits. But if you said, well, it's Smith, but it's in Clinton or Lancaster or Sterling, you can refine it to that, and it'll spit out whether there's something. And they're kind of cute about it because they say it's either under $100 or over $100. So that's the extent they give it. And then if you call up and you ask about it, they'll say, well, what's your social security number? Where do you live? And things like that. And you have to prove certain things before they give it, share the information, and then they would send you a claim form to get it. So, but when you petition the court for a will, you're kind of petitioning for 2 or 3 different things. One, it's you're presenting the last will and testament of somebody, and you say this was the official last will. And then you're also petitioning for the person to be named as the personal representative or that executor. So when you do that, there's an opportunity for people to object. Maybe a lot of you don't read the legal notices, but if you get the item, read the legal notice, there's usually foreclosures and there are petitions for probate. And that's where somebody can raise an objection and you say, well, no, I don't think that person is the right person, or I have a more recent will. I'm sure all of you have been around when there were supposedly all these versions of Howard Hughes's will when he died. But and the thing is, on a will, the very first paragraph says this revokes any will that I made prior. So once you have the new will, and we as attorneys are supposed to take a will if you know somebody that died, and if the family hasn't come to see you about opening the estate, you're supposed to take and file that with the probate court. So then they have that on record that, in fact, somebody died. Okay. I don't know, questions on that, or shall I keep going? I'll come back and answer any questions that you might have. So if you are making out a will, probably the most important thing is to make a list of your assets. And invariably people say, well, I don't have much. And then you start saying, well, let's make a list of it. And they have much more than they might think, or they think they have things a certain way, and they really don't have it that way. It would always bug me when somebody would come back to the office and say, well, I went to the bank and they told me, if I put my daughter's name on the account, I don't have to go through probate. Or if I put their name on the house, I don't have to go through probate. And my response would be, you're absolutely correct. Well, what about the other 4 kids that you have? Because now if you put so-and-so's name on the deed, they can say, well, I was always the favorite and I'm keeping it. Or you'd like to think, well, the terms of the will would prevail, but that isn't always the case. So typically what I have, and what we'll do is, if somebody I'll ask about joint bank accounts, and if you say, yes, I do have them, then we put a paragraph in there. Either it's my intention that any joint bank account that I have with anyone else goes to them, or no, was only on there their name was on there for ease of administration, and it goes as part of my will. But it's awfully difficult, and you can imagine how family disputes, erupt. I had somebody making a will and giving everything to her brothers and sisters, and she had, but then as more we talked, she only had one bank account, and it had somebody else's name on the bank account. So now I'm saying, well, all right, either if this other person keeps the money, then all of the brothers and sisters are going to be ticked off. But if you want her to have the money, then you need to say that. And of course, if that was the case, then we'd be talking again, well, why are you making this will, giving everything to everyone else? So, so it's important to kind of make a list of all of the assets. And then, are they mine? A lot of people, married couples, will say, well, this is what we have, okay? And that's fine, but if you have an IRA, that's only your IRA, or it's your spouse's IRA. Or if you have a 401k or 403b, they're one or the other. You might have designated beneficiaries to each other, but it is only one or the other party. Bank accounts can be joint. You can have a bank account that you can change if, now, with all that said about adding somebody else's name on it, a lot of people don't like to have their will recite something less than equal. So if I had a will and I had 4 kids and 3 of them went off to tackle the world, and one was always around helping me and provided a great deal of assistance, I could name a bank account and say, POD, payable on death, or sometimes they use transfer on death, where you can make so that they get that account. All right, the other thing I guess I wanted to make sure that we talked about, and then I'll circle back on any of these issues, is mass health. So the nursing home is filled with people who never ever intended on going to the nursing home, but for one reason or another their health didn't cooperate, and they are there. So there's a set of rules, and they're fairly basic, but there's a set of rules for a married couple, and there's a set of rules for a single person. And if you're married and both people end up in the nursing home at the same time, then it's like the single rules apply. So the married couple, the healthy spouse, or the so-called community spouse, can keep the first $120,000 of assets, and they can keep the marital home. Okay, so if you say, well, we rent an apartment, but we have a house at the Cape. Well, if your voting registration isn't at the Cape and your license isn't at the Cape and all that, then that's not considered your primary residence. So the healthy spouse can keep the marital home and can keep $120,000. The rest of the money that you have is supposed to go to pay for the ailing spouse's care. Now, if you're a single person, the rules are spend everything down to $2,000, and we're going to liquidate your house, and once you reach $2,000, then you're deemed eligible for mass health benefits. So now, there are a number of things that you can do, and it all depends on whether you have done it in advance or if you are in the emergency mode. So and there's a 5-year look back. That means when you apply for mass health benefits, they say, let's see everything that you've done for the last 5 years. And if you say, well, I have nothing, then they'll say, okay, but now I want to see your income tax returns for the last 5 years, your bank statements for the last 5 years. I want to see everything that you did. And when they see that, well, 5 years ago you had all this money, and then they start asking questions. Well, what happened to this? Oh, I gave that away. I did this, I did that. So those would be referred to as disqualifying transfers. So if you apply, you have to disclose to the Commonwealth of Mass what's happened for the past 5 years. So they scrutinize it every which way, and their goal is to deny benefits, because if you think about it, that's probably the biggest part of the budget for the Commonwealth of Mass is for Medicaid or mass health benefits. So they've taken a very strong stand, and unless you qualify, they're going to deny you. So now, there are a whole bunch of things that you can do, and the key is, of course, if you do something well enough in advance. So but there are some exceptions to the disqualification rules right off the bat. So a married couple, one spouse can transfer the house to the other spouse, and if that was the only asset, the spouse is immediately eligible for mass health. I've gone to the nursing home, have had somebody sign their house over to their spouse, and they were immediately eligible for Mass Health. Okay. Now that sounds great, but that's kind of like the emergency mode, because now, in one case I'm thinking of, the person was about 90 years old. So now you say, well, now the other spouse has the house. The basic problem is typically that the other spouse is close in age to the one who's 90. So now, do they have 5 years to be able to do something, or do they, is their demise a quick demise? So you can do that. You can transfer your house to a son or daughter who has lived with you for the last 2 years. And typically on that, you need to deliver a doctor's note who says to the effect, yes, I know that this son or daughter lived with that person for the last 2 years, and in my opinion, the person was able to stay at home or live in the community that much longer because of the presence of the son or daughter. There's another exception if you are putting it in trust for a disabled child. Okay, and there's a fourth one that I know of. If somebody died and you owned a house with a brother or sister and they lived in the same house, then you can transfer your interest out to that brother or sister. So those are the basic exceptions, and there aren't many, but those are still available. So if you don't have one of those exceptions, then you have to look at qualifying by making a transfer more than 5 years prior to your application for Mass Health. Years ago, it used to be a disqualifying factor, and they had something like $250 a day. So if whatever you gave away, you would be disqualified at the rate of $250 a day, and if you expire, if that was longer than the number of days came out to, then they wouldn't look at it. Now they changed it to a straight 60 months. Everything you've done for the last 60 months, that's what they're going to look at. Now I know I said about the transfer to a son or daughter, that kind of sounds awfully familiar with adding the son or daughter to the bank account, which I'm not a big fan of, because the power of attorney can access the bank account, but the account is still in the person's name. But so many times what you may do is you might sit down with a family and they say, well, we qualify because we can make the transfer to this son or daughter. Well then, after the person has been approved for Mass Health benefits, then typically the children would get together, because if it is mom or dad's intention that it's going to go equally amongst the children, then they would do something where the child who received the house would add the other children's names onto it, or they would give a mortgage to the other children. If you have 4 kids, so you give a mortgage out to the other 3 for 75% of the value, and then they know if something happened to this child who has the house in their name, they die, then they're still going to get some portion of the asset. So, and like anything else, an awful lot of it depends on cooperation, how well your family members get along, and that's the key. I'm sure I'm telling you some stories, but each one of you could say, well, I remember this scenario where somebody, some family member didn't get along. And I've had people who do things with the best of intentions, and even with that, it comes back to be problematic. I had somebody where left an estate, a third to one child, a third to another child, and a third to an education trust for his grandchildren. Okay, well, that was a problem, to some degree, because after he died, one child said, well, she's the one with 5 kids, I don't have any, or, oh, thank you, or I only have 1, so her children are benefiting it, more than mine. So, as I said, the best of intentions can backfire, but all you can do is what you think is fair and reasonable in your mind. Now, if there is enough time back to Mass Health, if there's enough time, there are some other planning devices that you can do, and the most common one is an irrevocable trust. And that's where you can put assets in there. You can put a house, and for most of us, the house is the least offensive of all, because you can put the house in the trust, you're going to live there the rest of your life, and when you die, the house is going to get distributed out however you say. You know, it would mirror your will, or it's going to have a disposition clause as to who gets what. So, like I said before, the trust would have to be in place for 5 years. Okay, so if you have that in place, and so you can set up the trust. So it's kind of like you have to think about it. Not how am I at 62, how am I at 67? Well, if I'm 72, well, how am I at 77? Of course, if 80 to 87, because that's the 5-year window that you're looking at, you know, how healthy am I going to be? And I guess if we had the crystal ball, all of us would be doing something different than we are now, but that's the basic rule, is 5 years. So, and that's a tough decision. I know, you know, probably none of you were born before 1929, but I'll say that's the Depression era mentality, where people, I find, are really, it's ingrained in them to save for the rainy day, and I want to make sure I have enough money to live on. And probably the two things that always jump out with people that when you sit down is involving the government with taxes, and do I have enough money to live on? So, but that's kind of what you need to think about. So if you put a trust together, well, you might say, well, I want to put everything in the trust. Well, the terms of the trust say I can get the income from the trust, but not the principal. Okay, so if the house, as I say, that's the least offensive, because if you say, well, I'm going to live here the rest of my life, then I don't care if it's in somebody else's name or some entity's name, because I'm going to have the right to live here. But if you take, you know, $100,000 and put it in the trust, well, all you're going to get is the interest. And most of us know you're probably only getting 0.5% or less in the bank. So that's all you would be entitled to get from the trust, is the interest. Now, you know, if you had, you know, several $1 million in the bank and you're getting 5% interest rate of return, you know, now you've got a substantial amount that you know, can supplement your income from. But, so the trust is something, at least, you know, that's an avenue that's available. I had somebody one time who husband was sick, and we ended up creating 2 annuities. And as crazy as it sounds, an income stream is viewed differently than an asset. So what we did was we had somebody who had an IRA, and what we ended up doing was creating an annuity where the healthy spouse bought an annuity for herself, and you had to have it paid over the life expectancy of that person. Okay? So what it did, though, it changed an asset that would be subject to spend down to an income stream, which this woman was able to keep all that money. So you don't set it up years in advance, because if you have an annuity, it starts paying out right away. So now you can be kind of counterproductive to what you're trying to accomplish. So, but that's an avenue that sometimes is available. It's very effective when there are 2 spouses. The problem is if you're single, then the Commonwealth of Mass will disqualify you if you have that, unless the Commonwealth of Mass is named as the residual beneficiary. So they kind of say, okay, we'll advance the money, but then when you die, we want to get it. So, and if somebody had that, you'd want to change it so Commonwealth of Mass, to the extent that I have a Mass Health debt, okay? Not the whole balance, because if you went into the nursing home and died a month or 2 later, they might be entitled to $20,000, and but you don't want to give them the whole amount. You know, so there's some fine details to at least think about. The Mass Health rate is different than the private pay rate. So in the nursing home, you know, some people say, well, should I put my house on the market, or should I sell it before, or should I just put it on the market and go to the nursing home? Because if you have your house and you put it on the market, they'll say you're eligible for Mass Health benefits, but you're still supposed to keep marketing the property. So if you are in the nursing home, many places are running around $400 a day. Okay, so that's a substantial amount of money. every day. I'm venture most of us haven't paid $400 for a hotel room in the best location, but that's what they're charging. But the Medicaid rate is probably under $200 a day. It might be more like $100 a day. So sometimes you can kind of strategize. If somebody is in very poor health, say, well, let's not sell it yet, put it on the market. Mass Health will have a lien based on the Mass Health rates, not the private pay rates, and if the person dies, then Mass Health will have a claim, but only at the number of days at the Mass Health rate. Okay. I know it sounds crazy. You're kind of strategizing on people's lives and their assets, but I think the common feeling with most people is, geez, I worked pretty hard for what I have, and my spouse worked pretty hard for what I have, or my parents, or however you ended up with the asset, and I really don't want that to go out to the pay for my nursing home care. There's some people that say if it takes every dime, that's their decision. Have the other extreme, I don't want anything, and then there's some in the middle, well, I don't mind some of it, but I don't want all of it to go. So that's where you kind of have to make an informed decision. Excuse me. So, like we'd say to somebody at the office, if we throw out all the rules, and if you say, this is how I feel about it, then that's fine. That's your decision, because that seems to be right for you. And we can say, well, here's how you can save things, or here's what you are at risk. And if you say, well, I want to have $100,000 in my name, and I don't care, I'll put the other assets in the trust, or I'll do something, then that's fine. Because that Depression era, mostly those people are saying, I don't want to be tossing in bed at night thinking I don't have enough money to live on. So, and that's just human nature. All of us, have worked hard to get whatever we have, and so that's a personal decision. But it's another thing I will say. People always ask, what about this $10,000 per person per year gift? Okay, and that still exists. In fact, it's now $14,000. So, but what it is there's an estate tax. In the Commonwealth of Mass has an estate tax, and the federal government has an estate tax. So the Commonwealth threshold is $1 million. The federal threshold is $5.5 million. But with the $5.5 million, it's a unified credit. And what it says, you can give away up to $5.5 million while you're alive, or you can die with $5.5 million in your estate when you die, and that's tax-free. Anything above that would be taxable. So, but if you make gifts while you're alive, then you either file and pay a gift tax, or you say, no, drop my $5.5 million to 5.4, 5.3, whatever, however much you gave away. So then the government came out, and I know, I have an accounting degree, so I took tax courses in college. So back in the 70s, it was $10,000 that you could give away. And that stayed pretty much the same till about, well, maybe 10 years ago. And then it became that they escalated a little bit. So on the federal side of the government, that's taxation, they say you can give away $14,000 per person per year, and that is fine with us. Okay? And that falls under the radar of the gift tax return. That's the federal taxation arm of the government. The Medicaid arm of the government says, okay? So that's a disqualifying transfer if I gave that money away, and they say, no, disqualified, you have to get that money, get it back in here, and they hold pretty firm to making a vigorous effort to get that money paid back in. All right, so I talked about things while you're alive, power of attorney, healthcare proxy. Power of attorney is legal and financial. Healthcare is just healthcare decisions. The will, who gets what when I die. The difference between probate assets and non-probate assets. So a joint bank account is a non-probate asset. Okay? But if your will says, I want it to go to all my kids, then you kind of go to the person who is the joint holder and say, are you going to divide it out amongst everybody, or are you going to put it back into the will, into the estate? So non-probate assets have designated beneficiaries or a joint owner. Non-probate assets are assets just in your name, okay, without a beneficiary. And again, a non-probate asset can become a probate asset if the beneficiary died before you, okay? So, so those are that's generally the probate process. There is a small estate avenue that they have. So years ago, you would either have to open an estate, you would have a formal filing of the probate. You'd have to give notice to everybody, the heirs at law. Everybody would have 6 weeks to object to your appointment, and then you would get appointed. So then when they changed this uniform probate code, they kind of made it a little bit easier. So they have what's referred to as an informal probate process. So if you know all the heirs and you can get all their assents, then you can file it and you get approved, within a week or two. So that's a great process for when people are all getting along and you can move things along. But they have a small estate, and that's called a voluntary administration. So on somebody who dies, if their assets amount to $25,000 or less. All right, so let's say you have a joint bank account, you have one child, a joint bank account, you have them named as a life insurance beneficiary, but you have these savings bonds that you've been hanging on to, then those could be, as long as they amounted to less than $25,000, you could process that through the probate court and go that route. So that's pretty good, and like many of us, when you if you die and you have a spouse, well, the house is joint. They have joint bank account and joint investment account, IRA or 401k, have a designated beneficiary. So you say, all right, well, if I die, what do I have? I have my car, and I have an old car, and I got my golf clubs. Everything else is joint. That's the reality is. A lot of us, because you kind of think of that as, well, what's mine is yours and yours is mine. So, but on the second one to die, that's where the whole estate administration takes place. In probate, I know some people will say, that's like a dirty word. It's not necessarily. And there's some tax advantages of it. If I have a house, I bought in 1978, and if I just gave it to one of my kids, okay? Well, the basis, my purchase price, is $44,000, and if I gave it to one of the kids, now their basis is $44,000, okay? And if it's not their primary residence, they can't sell it and take the beneficial sale of a primary residence, as if they're single and they sell it, a primary residence, you can sell up to $250,000 with no tax. And if you're married, you can sell a house up to $500,000, no tax. So if I gave that house and it's not their primary residence, then their basis is going to be that 1978 purchase price, not today's value. But if I die and it's in my will and they sell it, or they sell it after my estate is settled, and the house is worth $300,000, they get it at today's value, they sell it, zero capital gain. So there can be benefit, to having it go through probate. So I don't know. I could give you examples of things. I'm happy to talk with any general question. If you want to ask a general question, we could keep the tape going. If you have an individual question, I'll stay. I did bring a bunch of forms that just kind of it's kind of like a client information sheet. And whether you came to me or you went to somebody else, it's just good to kind of evaluate or determine what is it that you have. Because again, like most of us, you may think, well, I don't have much, and then you start adding things up, and you say, well, gee, I have a lot more than I think. And at least get you thinking. Now somebody will say, well, how often do I need to change documents? And to change a will, you can change it whenever you want. You know, I kind of was a comical case 25 years ago. So they were probably good for like 3 wills a year. And honest to God. So one of the paralegals said, well, should we be witnessing, I gave some that side, should we be witnessing this because they're changing the will? Well, they were an elderly couple, very elderly, and you went to see them at Christmas time, and I didn't. Okay, your stock went up and mine went down. But in the summertime, I went to see them and you didn't, and so they were kind of troubled like that. Now, if they were making changes to the Animal Rescue League this week and the church next week, and really wild, then you do kind of think about it. But that was kind of a comical one. But how often should you change it? I guess not that you want to dwell on dying, but you say, if today's the day I die, here's how my will reads, and if you say, well, it's still the way I want it, then there's no need for a change. Now, if you won Powerball, well, maybe you do want to change things, but if you say, all right, if I died, here's how it's getting distributed, and if you're okay with that, then no need to change. So that's the will. Now, there are all kinds of people my age that still have Uncle John as the executor of Mom or Dad's will because they never changed it, so that can be, somewhat problematic. But the power of attorney, what I find is after about 6 or 7 years, the banks don't want to recognize it, okay? Because if you have this power of attorney, then they're calling us saying, well, so-and-so's still your client, and can you give us a letter that, they haven't changed the power of attorney? So, so occasionally that's not a bad thing to update, and but you really don't have to change documents. Well, there's one comment I wanted to go back to the trust. Because a lot of people say, well, why don't you just put your son or daughter's name on the house with you? Okay. Well, that's fine. So that's great now. What happens if they get divorced? Well, the ex-in-law is now wants a piece of the pie. What happens if they file bankruptcy? What happens if they get sued? Things like that could happen that you say, well, geez, that wasn't what I was intending, but nonetheless, that's the situation at that point. So the trust kind of gives you some control. And the trust says, right up to including in my will, I can reshuffle the deck and I can decide who's getting what. Okay, and there could be some reasons why you may want to cut somebody out. Now, the worst one is they've wronged me and now they're out. Okay, but kind of unfortunately another scenario that happens more often than you might think is that you've got this son who is disabled, has MS, Parkinson's, something or other that renders that person in the nursing home. So I had somebody recently when after discussion we kind of said, okay, well, she was going to not cut this person out, but say the share that would have went to him is now going to his children because not that I don't love him anymore, but I want to provide for his family, and if he's in the nursing home, he's never going to be able to provide for his family. So they bypass. So in the trust, you can kind of make provisions for things like that. Not anything that any of us want to think about, but nonetheless, that does happen. In the trust, you can have, I had somebody else that said, well, I have 2 kids, and I'm giving everything to my daughter, okay? Because my son's involved in a nasty divorce, and none of that money is going to go to that person, okay? And I'm confident that my daughter is going to take care of her brother. I don't know, we all have different ways of thinking about things, but the trust enables you to make changes like that from time to time. So.
Now, is that in your irrevocable trust you're talking about?
Yes.
You can make changes to them?
Well, you can make changes to the distribution,
Okay.
not
Trust.
Yeah, not the terms of the trust itself. If you have, the question was if you're irrevocable trust, so it's either revocable or irrevocable. And if you have a revocable trust, then the Mass Health intake will say, well, you have the right to revoke it, go exercise that right, you've got the money, you don't need us because you can privately pay. The irrevocable trust is, it's out of my hands, out of my control, But the only way you can change it is now is in my will, I can reshuffle it and say, okay, it was going to go equally to these 4 people, or no, I'm going to bypass this person and give it to their children or their spouse, or something like that.
Are you looking for questions?
Yes, I mean, I would only say if we keep this running, if they're general questions. If there's something personal, I would rather say,
It's
yeah,
about
okay.
irrevocable trust. You were saying that there's usually 5 years that Mass Health is looking at.
Mhm.
If it's a couple, and the trust says, I leave everything to you, you leave everything to me kind of thing, and one passes before the 5 years is up, how will Mass Health consider that?
Well, the trust probably wouldn't have, I give everything to you and you give everything to me. Because now you're not, you're not safeguarding
No,
it.
two separate trusts is what I'm saying.
Oh, I'm sorry. All right, so you have 2 separate trusts. If the 5 years are not up, they're going to disqualify.
It will what? They are, or they are disqualified?
They're going to disqualify the transfer because it hasn't been set up more than 5 years ago. But I guess if you said that it's going to my spouse, then they would...
That's the only one that goes to.
Okay, but they're probably going to look at that and say, well, your spouse, you two combined still have the asset. You still have control over the asset, and I think they're going to disqualify on
The
that.
only assets that would be left would be bank accounts.
They don't differentiate between land or bank accounts. If the big thing is, in the trust, do you have control over the trust? And if you have any semblance of control, they're going to disqualify you.
Okay, unless it's, you said, this is where I got confused. You're talking about a community spouse and a widow or widower, which would then be considered a single?
Yes, if you're married, the community spouse is the one living at home
Okay.
versus the institutional spouse. But I said, if I'm married and my wife's in the nursing home, and then I get sick and have to go to the nursing home, the single rules apply.
Okay.
Okay, so then they say spend everything down to $2,000, and you can have $2,000 and she can have $2,000, that's it. Okay, so they make you sell everything.
Okay, so if everything is gone, but there's an irrevocable trust for cash, that has to be spent down to 2,000?
Well, no, if it's an irrevocable trust and it qualifies under Medicaid, then
It's not
that,
5 years.
well, then no. They would, now, if you said, no, there's some fine lines that you get
We're
into.
getting too specific.
No, but,
Sorry.
well, let's say if somebody, let's say I'm 4 years into it and I have this property in a trust, and then I get sick, so now there's 12 months left. Well, if the house is worth $100,000, that's not going to matter, because if they pay for it, they're going to spend it. But if the house is worth $400,000 or $500,000, then I'd be saying to the kids, okay, each one of you ante up a month or two's payment to get to the 5 years, and then we're going to apply for Mass Health after the 60th month has expired. So there's, again, things that you can do. Like anything else, it needs willing and able players. I'm sorry.
What does it cost to set up a trust?
Well, trust is probably going to run you around $2,500. A set of wills, is probably like $750. But in the end, you probably say, well, I'm not putting everything in the trust, so you need a will too. So it can be expensive, but it's all going at what am I trying to protect? What am I trying to save? And so, and of course, you can always take some money and stick it in the safety deposit box. That's I would say that versus having it in the mattress. That's just not a good idea. But there was a great story on History Channel. Denny McClain was the last 30-game winner in baseball, and he had a fire in his house. And they were talking about him running back in to get the Cy Young trophy and his mattress. Well, apparently after he got out of baseball, he was a very good golfer and made a lot of money betting, and the mattress was the safe. So,
So,
yes, go ahead.
life estate,
Yep.
or a I think there's two names for it, is a life estate.
Mhm.
Are they now, if you have 4 people, say that own the property, and one person has the life estate, aren't they counting that as
Yes.
a quarter of ownership?
Well, oh, yeah, let me see. I'll answer it 2 ways because it's kind of a mixed question there. So if I'm the parent and I transfer the house to my 3 daughters, okay, and I reserve a life estate, okay, then if I'm the one who gets sick, they're going to value the life estate based on my age, based on that percentage. So if I'm 90 years old, I probably have like about an 8 or 10% interest in the house, okay? If I transferred it from me to the 4 of us, so now I'm a quarter owner, and I have the life estate, which some people like to put, 2 Band-Aids on the situation, so they don't want to get tossed out, then a quarter of the property would be includable in my estate. It's like, it's in mine if I get sick, it's in yours if you get sick, and you're right around the table. Some people say, well, I put my son or daughter's name on the bank account. Well, if you're the one that gets sick, they're going to deem it's yours. If the child's the one who gets sick, they're going to deem it's theirs. So it's. But yes, the life estate is valued based on a mortality table. So it's kind of like the reverse of age. If you have a life estate given to somebody who's 10 years old, they probably own 90% of the property. If the person is 90 years old, they probably only have 8 or 10% value.
Thank you.
Okay, yes.
This is going back quite far, but you talked about a HIPAA, and I'm not sure what that is and why I need it.
Okay. Well, it's the healthcare proxy says I'm appointing somebody to make healthcare decisions for me. And you'd like to think that that is going to be sufficient for anybody to give the information to the healthcare agent. It doesn't always be the case. So the HIPAA release form, it says, I'm going to authorize all this confidential, proprietary medical information about me to somebody. And usually you would name the same person who is the healthcare agent so that they can get it. Okay? And yes?
It's not just HIPAA though. I'm running into this with my parents. I'm trying to talk to people about the retirement benefits, and they didn't set up third-party representations. So what I'm finding out is I have to go back through doctors to get representation signed, which is taking time, energy, and aggravation. So if you're going to be getting a retirement benefit, Social Security has third-party representation. Anything that they are going to get money from, you need third-party representation on top of everything.
Yeah. Oh, it's when you're stuck, it's terrible. It's just so good planning is just
And
having
set it
some of
up
that stuff.
beforehand,
Right.
there's no issue. We didn't even know it existed.
I had somebody recently, a young guy, was sick, medically induced coma, and so his wife came in. They had 3 or 4 kids, and couldn't access anything, nothing. Okay, so the added thing was they spoke a foreign language, so I needed an interpreter to do it. But but without that power of attorney, without the healthcare proxy, although they were intact family and happy family, it just one doesn't automatically give you the right to do something.
But power of attorney doesn't replace third-party representation.
No, you got to get real specific on signatures and authorization.
With the HIPAA paper that's needed, if that is not in my father's packet, and now he's been diagnosed with moderate dementia, Alzheimer's, can he sign that and will it be held according to what is needed in the future?
Maybe we should go off there. No, you kind of have to use anybody who's witnessing something like that. I think they use a certain amount of judgment, okay? And if somebody has Alzheimer's, I don't think that necessarily means they don't have lucid moments, okay?
Correct.
And I think you would probably want to time it on a day when somebody, you felt that they were competent, they did understand what they were signing. And so I think that's important. It's important to have, but I don't think you're necessarily out because he has this diagnosis now, okay? But it's, I guess if in doubt, you can always ask the doctor, do you think he understands this? And, get his or her opinion. But I would typically, if I went to see somebody, you just ask them about, the Red Sox, politics, something or other that, that they'll usually have some feeling about, and you kind of get to a point that they know what they're doing, and get around to, well, would you like to have, so-and-so helps you out, and they're your healthcare proxy, would you like to have them to have access? Yes, and so it's, but if you know somebody is absolutely incapable, that's a hard thing to ask anybody to go witness. But I think that lucid moment is kind of the key.
My daughters have authority to make healthcare decisions for me. So do I need a power of attorney also?
Well, the healthcare proxy is only for healthcare decisions.
Oh,
So if you want them to be able to pay your bills or to take care of any financial or legal matters, then yes. But if you say, no, all I want them to is for healthcare, then no. But if you did have need for financial or legal decision-making, they would have to go to the probate court. Once you were determined to be incapable, get a doctor's certificate, petition the probate court, and get a guardianship.
their names are on my account anyway. So does that make?
Well, that would cover for paying bills. I'm sorry, can you hear what I'm saying? Okay. So that would cover for paying bills. But if the reason you're unconscious because you got hit by a car, okay, the power of attorney would have authority to sue the person who hit you. They'd have the authority to file your income tax return, to whatever.
Oh, so they couldn't file my taxes?
Not legally. But a lot of people will say, well, I'm going to go do it online, I'm going to have direct deposit into your account, and some people would kind of get around that, but legally you're not supposed to.
What about the trustees on a trust? One of the trustees is put in the nursing home, and the nursing home require that trustee to let the trust pay out to them because they have.
No, I guess you'd like to think nobody is that devious that they're going to say, here, sign this. But most of the trusts are set up so that you have a primary trustee, an alternate or a successor trustee. I had a trust that I set up, and husband and wife were the trustees, which today they don't advise that anymore, but it was quite a while ago. So the woman had died, the dad was in very poor health. So the son was the successor trustee. He tried to go to the bank said, no, we're not going to let you do this. So they needed a medical certificate. Now, they had hospice at home, and they were trying to keep the father at home, so either they'd have to get a doctor's note who went to the house, or the person would have to resign. So I ended up going to the house, have the father resign, takes the death certificate and the resignation, goes back to the bank, and now the successor trustee can transact. So you'd hope to think nobody's saying, hey, you're the trustee, just sign this, but I suppose. Did I answer your question, though?
No, not really.
All right.
I thought that there was, that they were trying to pass a law that said, like, the trust protects the assets from the nursing home being,
Yep.
paid out of your assets.
Yep.
But if it's the primary trustee that is in the nursing home,
Okay.
then is the trustee you know, or can they
Well-
require the?
Well, the terms of the trust would generally say, I cannot get the principal out for me or for my benefit. Okay, so it has that language in there, they should not. The most recent strategy is to name somebody other than the parent as the trustee. So typically you'd name, okay, I'm going to name one of my kids or two of my kids or some independent person to be the trustee. But the term, if it's a revocable trust, the person has the right to go get the asset. If it's irrevocable and it qualifies under the terminology, then they cannot get the principal, and then they could not force the person to use it. Okay. Oh, yes.
Quick question. On a bank account, the difference between pay upon death and somebody else's name being on it.
Well, payable on death is, I have an account, it's in my name, and you are payable on death beneficiary. While I'm alive, you can't touch the account. You might not even know about the account, okay? Unless you had power of attorney, you could access it, but that's under the power of attorney authority. But if it's payable on death, you only get it upon my death. They need a death certificate. If you're a joint signatory on the account, while I'm alive, I go to Myrtle Beach golfing for a week, you go in and clear out the account. So no, I mean, it's that, so a joint account, you're given an awful lot of authority to somebody. I had somebody one time with talking about a power of attorney. He said, well, that's only a license to steal. So, I mean, there are different theories. If, you know, you have power of attorney and, you know, the three of us are saying, well, wait a second, she's doing things for her own benefit, not for the good of, you know, I mean, like any other family dynamic, it, you know, there are strong feelings one way or the other. So the thing is, you want to name somebody as the power of attorney, somebody you absolutely trust, okay?
On an irrevocable trust, the ones that I've seen, there is a statement in there that says the executor can dissolve the trust. How is that possible? Because it's irrevocable for a particular person.
Okay, you kind of mixed a couple of terms, but we're still going. So, yep. So if you had, just say what you said, because you used the term executor. Executors in a will, trustees in a trust. So,
The trustee.
okay, so it says the trustee can dissolve it.
Yes.
Yeah, new trust, where you have somebody other than the parent being a trustee. Many times you have a provision where the trustees can make certain distributions of money. They can't make it back to the parent, but they can make it to somebody else, okay? And that's kind of a way where you might say, well, we're all, you know, we're a family that gets along, and, you know, so if somebody needed some money, you might say, okay, I can't give it to you, Mom, but I'm going to give it to you, sister, and maybe you're going to turn around and give the money back. But if you set up that routine, they look at that and they'll say, oh no, this is a sham. This is not a real trust. It's you're doing this.
Yeah, I didn't understand how the could dissolve it.
The trustees, you know, many times they'll have the authority to give assets out, not to the parent, okay, but to somebody else.
Okay, the way the trust is written, it says it's for money for your surviving spouse. And once they're gone, the money can go to others. That's my understanding. Maybe I'm wrong.
Is this a real one, or is it you?
It's a real one.
Well, I don't know why somebody would set up the trust saying it goes to my surviving spouse if they're trying to, the principal. If they might say the interest goes to the surviving spouse, then that would be the key. Is only the interest goes to them, not the principal.
I was surprised they were going to dissolve it.
You have to take a look. It's kind of hard to,
Without seeing it.
yeah.
Now we're getting too specific.
Okay. Well, I'm glad to stay if anybody has any particular questions you want to ask without everyone else hearing it. But any other general, yeah, on any of them, power of attorney, healthcare proxy, the probate process.
Yeah, you used the term for the medical, advanced care directive, is that the most? Or is that a different?
That's a separate form, but it's that's the one that says, I'm going to tell you, my healthcare agent, that if I have this circumstance, I don't want to be kept alive, okay?
Okay.
So that's,
That's the 5 wishes?
well, it's kind of, yeah.
Okay. I recall 5 wishes more an advance directive or anything, they were all the same.
I don't use that 5 wishes term, but it's really just a guide. Now, if you go in for open heart surgery, that doesn't mean they're not going to put you on a ventilator, okay? If you have a stroke, that doesn't mean they're not going to do anything. It can be fatal, and if you have some diagnosis of some illness, and somebody says, well, there's no cure for that, that doesn't mean they're not going to do anything. It's more, I'm really at death's doorstep and I'm not, going to get any better. And so then it's, okay, give me painkillers, but no extraordinary means. There's always that, remember there was a case down in Florida, I think it was Terry Scheibel, was somebody, the husband was saying she didn't want to be kept alive like this, and her family was saying, oh yes, she did, and you get into all these things of who's collecting insurance, and I mean, it's all it's posturing.
That's all my questions.
Okay, then I'm glad to stay for a minute. Oh yes.
Does my power of attorney stay good forever, or does it expire?
Generally, it will stay good, but as I said before, banks certainly don't want to use it if it's more than 6 years old.
When my parents set this up, it was in 2008,
Yeah.
but I didn't need it until 2016.
But did you give a copy to the?
I gave a copy to the bank.
Okay, then it's good.
I guess I haven't had any real problem with it. And another question is, I have a family trust and a will. Doesn't really say anything, but those were done at the same time. Do they need a new one?
Well,
There's really nothing in it.
well, it depends on what you're trying to accomplish. So I suspect if you have a family trust, that's a revocable trust, and I would say you don't have any protection from Medicaid. Okay? I'd have to see it before you could say. So
Yeah.
if it's a revocable trust, you have no protection from mass health benefits and the rules for that. The will may not need to be changed. Like I said, if you said, if I die today, here's who gets everything. If you say that's still my intention, then there's no reason to change it. What I was saying about the power of attorney, if you have one and it's never been used, and then somebody tries to use it 8, 10, 12 years later, that's generally a problem. But if you had one and you gave it to the bank, and they copied it, and now they have it on record, that will continue to be good, because they've recognized it as being,
Right.
it's not going to expire.
When I went to the lawyer to get it, it was already really old.
Yeah.
And I guess he needed to restamp it because his stamp had already expired.
Okay.
So I had to go back and get another one that he actually did restamp.
Okay.
But it did make it difficult because people were telling me I needed it notarized and nobody would notarize it because it appeared it was already so old.
Okay. Power of attorney is supposed to be notarized. So,
Right.
but maybe restamped it to suggest to the bank it's still valid.
To 2016, so, but nobody would actually notarize it because they said they needed the original. I have what the lawyer gave them, but I guess not the original.
No, many times you don't. Now, we have a form that says you have this power of attorney, and it says we will only release it on certain conditions. So one is you call me up personally and say, okay, will you release the power of attorney to my daughter? One is something in writing from you. The third is a medical letter that says the person, is no longer able to handle their affairs. Then we'd give it out. But otherwise, we're not in the business of giving it out. I had somebody one time say, yeah, I'd like to see my father's will. And I said, well, you can't. And she was insisting. She said, I'm his daughter. And I said, yeah, but he's not dead. So if he was dead, I would give you a copy. But if you're alive, why stir trouble? Then legally, they're not entitled to it. Okay, I'll be glad to stay for a few minutes.